Hello, welcome to another video on education technology law. With me, I'm Justin Bathon, an educational attorney and professor at the University of Kentucky. Today we want to talk about data security, and in this video I specifically want to focus on what happens when a breach occurs and looking at some of the legal issues during that breach period. Okay? So I'm going to use the Data Breach Response Checklist published by the U.S. Department of Education and their Privacy Technical Assistance Center as sort of a guiding document. I'm not going to go through every detail of this, that would take hours, but I do want to highlight a couple of things that I think are important for you to be thinking about on the front end from a legal perspective, thinking about these breach eventualities that might occur. When you look at the data breach checklist, though, starting on page 4, they ask you to have a policy, to have a plan around that policy, and then to build procedures underneath of that. I really think this is a great idea and something you should be doing now, not after a breach has occurred. I can't recommend it enough. The reason why is from a legal perspective, judges are going to be lost through this process as well. And you're going to have general counsels on the other side for the parties that have lost their information, and they're going to be pushing hard to find liability on the part of the educational organization. If you are just getting into the courtroom and for the first time you start talking about, well, here's what we did in response to this breach, that is the wrong time to be looking at your policy and procedures for the first time. So I would also, a couple of tips that they have on page 6 that I think are really great from a legal perspective is to document on the front end what personally identifiable information you think is subject to potential hacking or loss. Knowing where that information is stored and how you're keeping it secure on the front end is vital, and documenting that, so that in the event of litigation, you can go back and say, hey, look, on the front end, we were keeping track of where the data was and how we thought it was secure. I also really, really highly encourage you to be keeping up with your data destruction policies and to regularly be destroying data that is no longer legally required to be kept. So each state has laws about how long educational records or employment information and other records should be kept. Keep it only for that long. Keeping it past that is just opening the school district up to unnecessary risk. So this document then goes on to talk about what to do in the event of a breach. Your natural instinct is to respond to those media inquiries as soon as they hit you. Definitely don't do that. There's a lot of steps you need to have taken before you start talking to the media or to parents or anyone in the public about anything that has happened in relationship to the breach. Okay, your general counsel has to be deeply involved in this. Also, there should only be one person speaking to the public and the media during this event, and knowing who that person is going to be is something that has to be determined before just the principal starts talking, the superintendent starts talking, board members start talking, and now we have just a nightmare scenario.